So let's say that I am pulled over. An officer does suspect that perhaps I'm driving under the influence, and it says wants to administer the breathalyzer, and I refuse, because I can refuse to do that.
Correct.
What then will happen? What are the consequences of refusing?
And you might as well refuse a field sobriety test. I mean, you don't refuse one and then do the other.
Right.
That's correct. If you refuse the breathalyzer, then you are arrested. That a refusal, you are arrested and you go to jail. Currently, the trend is that if you refuse a breathalyzer in many jurisdictions, I know St. Charles does this, I know that Jefferson has done it in the past, they will actually get a warrant to take blood from you to actually get a level of impairment from you if you refuse the breathalyzer. But you are in fact arrested if you refuse the field sobriety test. And what you said is that refusing the field sobriety as well, absolutely. You don't want to do one and not do the other. If you're going to refuse, you need to simply refuse everything and respectfully.
Well, give us some, from the, innocent until proven guilty. Maybe you had, and like you said, the way the law is, you don't necessarily have to be drunk. You might be a little bit impaired, you might have a little bit of alcohol in your system, you might have a little drugs in your system that's legally prescribed, but you are still able to drive safely. Maybe you got pulled over for some other reason. Maybe it's an accident caused by the other driver. What's your advice to somebody when they're in that situation? Should they submit to these tests? The officer will tell you, oh, just submit to the test, I'm sure you'll do fine.
Absolutely.
That's what they'll say.
Absolutely.
But generally speaking, is there, is there a recommendation that defense attorneys say that people in that situation ought to do?
Generally speaking, my position is that you refuse everything. You act respectful, you respond to the officer's questions, but if they're asking you to perform a field sobriety test or a breathalyzer, they've already got a suspicion that you're intoxicated. And the threshold is very, very low, and people don't recognize that it's not that you're drunk, it's not that you're falling down, it's that you may be impaired. And so if the officer in his training detects or suspects that you are in fact impaired and over the legal limit, then you've got a very big chance of being arrested anyway.
And we just want to make it very clear that we're not encouraging folks out there to go out and drink and drive. That is not at all what this is about. But you do have rights if you are pulled over, if an officer does suspect that you are driving under the influence.
And there are repercussions besides the possibility of a warrant to draw blood. What are the repercussions typically to anyone who says, you know what, I don't think I'm intoxicated, or maybe I think I am intoxicated, or I am impaired, and I better just refuse the test. There are some repercussions if you refuse the test. Why don't you describe those for us?
Okay. Well, once you refuse a test, the officer then arrests you, and you are brought to jail. Upon release from jail, from the date of the arrest, in the old law, you used to have 15 days to file for an administrative hearing. Now, that is regarding your driver's license and your ability to get a driver's license.
Your license is suspended when you refuse these tests, automatically.
Automatically.
But a lawyer, or even somebody without a lawyer, can attempt to say, I want to have an administrative hearing. That's what you're talking about.
That's
to try and get your license unsuspended.
Correct.
And tell us a little bit more about that.
Okay. Currently, the law in Louisiana is that you have 30 days from the date of your arrest to request an administrative hearing. And that is done through the Department of Motor Vehicles in Baton Rouge. And when you're arrested and released from prison, they give you a paper that actually tells you everything that you need to do and explains everything that you need to do to send that into Baton Rouge to actually request the test. My advice is that you get an attorney immediately. Because DWI is so time specific, there are only 30 days.
It's a serious charge too.
And it is a serious charge. And if you do not request the administrative hearing, then after the time expires from the date of your arrest, then that is when your driver's license begins its suspension. But if you do request an administrative hearing becomes available to you, and there's things that need to be done at this hearing that the ordinary person does not.
Is that when you would request a hardship license, or when does that happen?
At that point, the hardship license doesn't come into play until your license is actually suspended.
Suspended.
Correct.
Okay.
And just explain what that is, just for our viewers, so they can understand. What is a hardship license?
Actually, we have to take a break. We have to take a quick break. Time is really moving on.